is Mariana Rielli. I'm Institutional Development Coordinator at Data Privacy Brazil, which is an NGO focusing on data protection and other fundamental rights in Brazil. And I'm so happy to see you all here. Our panel, I'm going to just very briefly address the title because we talk about a lot of things, digital constitutionalism, and also the notion of data justice. This panel kind of started from the concrete. We were thinking about cases where, like, in different places where not necessarily you have data protection legislation enacted, but there are cases that could be very well considered data protection cases, and the interplay between constitutional norms and other types of normatives to uphold constitutional values in the digital age was basically what we were thinking about, and trying to have this discussion about creativity in strategic litigation. That was the whole idea initially, but then it kind of went in another direction that it also fits into this like big idea of the interplay between different frameworks. So we are talking more about AI and data protection, and all of my fellow panelists here have different takes and perspectives on this interplay between data protection legislation, upcoming AI legislation, and also talk from different places. So we have perspectives on the EU process, we have perspectives on the Brazilian process, and we also have many thoughts on what has been going on in Kenya and other regions in Africa. So basically that's the whole idea of the panel, and I'm going to briefly introduce my panelists. So thank you all very much. To my right, I have Katerina Demetzou, who's a policy counsel with the Global Privacy Team at the Future of Privacy Forum. And also here I have Chander, who's Senior Policy Advisor with the European Digital Rights, and has moderated an amazing panel earlier today. We were discussing that. And here to my left, I have Schertel Mendes. I said I was going to butcher the only Brazilian name. Laura Schertel Mendes, who's a senior researcher at the Goethe University and also a professor at the University of Brasília and the Public Law Institute also in Brasília, and was the rapporteur of the Commission of Jurists designated by the Brazilian Senate to draw an AI legal framework. And finally, I have to my right Risper Onyango, who's the digital policy lead at the Lawyers Hub, which is an organization based in Kenya, and they work with data protection, AI, and just digital policy in general. So having said all that, I'm going to give the floor to Laura, who will begin with her reflections on this interplay between the regimes, between data protection and AI, drawing on her very vast experience in Brazil. Thank you.
Thank you so much, Mariana, for the nice introduction. I would kindly ask for the PowerPoint presentation. Thank you so much. Okay, so I would like to thank Mariana and the team of Data Privacy Brazil for this kind invitation. It's a pleasure to be with you in this panel about digital constitutionalism and data justice across the globe. Just one moment. Okay, so as Mariana already told us, I'm a professor at University of Brasília and IDP, and I'm currently in Frankfurt as a senior researcher at the Goethe University with Professor Indra Spica. I am also a director of our Center of Internet and Society from CEDIS IDP, and I am the director, and the former director was Danilo Doneda. I have worked closely with Danilo, a data protection expert and a dear friend that passed away in December last year. I was pleased to see the tribute to Danilo made by the CPDP, and it was a great loss for the entire digital rights field, which has evolved a lot thanks to Danilo to Danilo's work and compromise. So considering the subject of the panel, I will talk about the evolution of the fundamental right of data protection in Brazil and the challenges it faces in the artificial intelligence era. I'll present firstly the Brazilian data protection landscape, followed by an analysis of the case law that helped develop the fundamental right of data protection. Finally, I will talk about the challenges faced by this right regarding artificial intelligence systems. So, in a nutshell, this is our data protection landscape. It has been quite a busy time in Brazil for data protection in the last years. As you can see, Brazil came a bit late to this data protection party, but we are rapidly catching up. Our Data Protection Act was enacted in 2018, and it entered into force in 2020. In the same year, our National Data Protection Authority was created, and in the same year as well, there was the first decision of the Brazilian Supreme Court recognizing a data protection fundamental right. And I will talk a little bit more about this decision afterwards. And in the year 2022, we had an amendment of our Constitution which recognized an explicit fundamental right to data protection. So the Data Protection Act in Brazil, which was partially inspired by the GDPR, is widely considered a very mature and balanced act, and the developments in the constitutional field have been seen also as a very important step to guarantee the implementation and effectiveness of data protection in Brazil, as I will try to show here. Now, moving on to the second part, I would like to present the case law regarding data protection as a fundamental right in Brazil. I'll present the two main cases that we have until today. So the first one is the IBGE case. It's a case that was a landmark since it was the first time in which the Brazilian Supreme Court acknowledged a fundamental right to data protection. It was ruled during Jair Bolsonaro's administration, and this could explain why the court saw, or at least could try to explain, why the court saw almost unanimously in a so clearly way, for the first time, the risks of data processing and sharing, especially considering the authoritarian inclination of his administration. This case, we call it AGIN 6387, questioned the validity of the Executive Order 954, which obliged telecom operators to share with the Brazilian Institute for Geography and Statistics personal data of more than 140 million mobile service users, including names, cell phone numbers, and addresses. IBGE is the public agency in Brazil which is responsible for the official collection of statistical information about the country, such as the national census. The data sharing was claimed to be essential in order to allow individual interviews for the development of relevant national statistics, since its staff couldn't visit households in person during the pandemic. The executive order has been contested in court by different political parties and the Federal Bar Association. They claim that it did not abide by fundamental legitimacy standards, such as purpose limitation, as it did not establish a clear correlation between the data needed and its alleged use, and transparency, since it did not provide the exact reasons the data were needed and the means through which they would be used. It was claimed also that the legal provision failed to address proportionality, as the amount of data required was not clearly justified. In this sense, the measure did not comply with the minimum use principle, according to which the use of data should be restricted to the amount necessary for its purposes. By the vast majority of 10 of 11 justices, the Brazilian Supreme Court held the executive order unconstitutional. This trial is a milestone for the country's framework because the Supreme Court has validated the constitutional status of data protection. Among other things, this means that future legislation and administrative acts are bound by principles such as purpose limitation, proportionality, and transparency. Above all, the decision allows the judicial review of ordinary legislation regarding this new recognized fundamental right. I'm moving now to the second case that happened last year. So the Brazilian Supreme Court delivered a further ruling on data protection. It was the first constitutional decision after the amendment of the Brazilian Constitution that established an explicit and autonomous right to data protection. The court held that a government decree that enabled virtually unlimited sharing of personal data in the public administration was unconstitutional. The decree had established a common public database, supposedly aimed to simplify the provision of public services. It was designed to work as a sort of data lake, gathering in one place all the pieces of information that Brazilian citizens supplied to federal public entities, such as biographical attributes, electoral data, and social security information. The ruling filed was important as it stated that data gathering and sharing within the public administration must be limited by specific purposes and always be carried out with guarantees of transparency and accountability of public agents. The judge rapporteur's vote concluded that the decree did not sufficiently protect the fundamental right to data protection, since it was still based on an outdated logic of intimacy versus publicity. The court then considered that the public or private nature of the data was irrelevant in light of this fundamental right. I would like now to tackle the challenges that we can or shall face regarding the implementation of this fundamental right in an era of AI. We have finally arrived to the main question regarding this presentation. We saw how the fundamental right of data protection has evolved and how it was important in the Brazilian context to limit state power, especially restricting unnecessary and risks-based sharing and processing in the public administration. The challenge ahead and the question that we now have to answer is if and how this fundamental right to data protection can still be effective in the era of AI. Several studies have highlighted the risks of AI systems, such as their opacity, complexity, dependence on a large amount of data, and discriminatory potential. AI and automated systems are valued precisely for their ability to process large-scale data and find non-intuitive connections and patterns between humans. Thus, the process of decision-making bypasses the individual without involving them. Thus, both the affected person's ability to participate and individual case justice are at risk if the affected person is not given the opportunity to present the details of their case or their perspective. On the one hand, AI poses challenges to the protection of legally protected groups. New and counterintuitive proxies for traditionally protected characteristics emerge but cannot always be detected. On the other hand, as posed by Sandra Varta, AI poses a challenge to the scope of the anti-discrimination law itself, as inequalities also arise outside of legally protected groups. But is data protection law intended for such cases at all? If we take a look, we can see that there are many limitations regarding the implementation of the data protection framework to AI systems. First of all, data protection law is limited to personal data. However, anonymized data or data from other persons may also turn out to be input from algorithms. It is not always personal data in the case of training data, and data protection would therefore not apply in this case. When we look to Article 22 of the General Data Protection Regulation, or our Article 21 in the LGPD in Brazil is an individualistic, limited, and ex post solution. And thirdly, data protection law has a more procedural approach, and the norms may have difficulty dealing with the consequences of information, focusing rather on formal safeguards. I know that these questions and limitations are yet to be answered and addressed, and that there are many scholars looking into right now. I can imagine that in Brazil, new cases regarding AI will soon reach the Supreme Court, which will have to address this question, since there are already cases in lower instances of the Brazilian judiciary, such as the one regarding facial recognition by the metro company Via 4 in the state of São Paulo. This debate is already happening also in the Congress, which is debating 4 bills in Brazil about AI. I could participate in the preparation of the bill 2338 as the rapporteur of the Legal Experts Commission of the Senate. And I wonder if this debate could have some influence in the confirmation of the fundamental right of data protection in Brazil, such as the influence that the LGPD surely had. Thank you very much for your attention, and I'm looking forward to the debate.
Thank you. Thank you. You guys listen? Okay. Thank you, Laura. That was a great overview of this interplay between what is happening with data protection at the constitutional level in Brazil and also the upcoming AI framework. And I'm going to move to Katerina because she also has some words, some thoughts on this interplay, but in the context of the EU, and also thinking about how, well, there are, of course, very novel challenges, but there have been recently also ways to deal with AI, including generative AI, mobilizing data protection. So I want to ask Katerina to talk a little bit about this interplay and some recent cases and what she thinks about data protection and AI. Thank you.
Thank you very much. Now everybody can hear me. Okay, good. First of all, thank you for organizing the panel and for inviting me. 1 second. I will indeed talk. So in my brief intervention, I aim to, first of all, highlight 3 cases that come from data protection authorities, 3 enforcement actions with regard to AI systems. And from that point, I would like to make an overall or a couple of comments with regard to the interplay between the 2 legal frameworks, so the GDPR and the AI Act. So I will begin with the cases coming from data protection authorities in Europe. The first one comes from Hungary. Should I put the timer, or do you keep the time? Because I forgot.
No,
okay.
It's fine. I can tell you.
Okay, good. So first case comes from the Hungarian DPA, and that was last year, referring to an emotion recognition AI system. With regard to the facts, a bank in Hungary was processing customers' personal data in the sense that customers that would call the customer service of the bank would have these calls recorded. And these recorded calls would then be analyzed by an AI-based speech signal processing software. The purpose of this software and this processing would be for the bank to determine the emotional state of each customer that was calling the bank to complain. So basically, to see the customer dissatisfaction, so the level of dissatisfaction of each customer, and then prioritize each customer to be called back by the bank. Now, the Hungarian Data Protection Authority saw many violations with regard to data protection, the right to data protection. Some of them, or the most important, were, first of all, transparency and information obligations. So the bank had not properly informed the customers that this was taking place. Violation of the data subject's right to object. Although there were high risks to the rights and freedoms of the data subjects, so of the customers of the bank, there were no appropriate safeguards taken by the bank in order to comply with the law and also the principle of data protection by design. There was also a major violation of the principle of lawfulness. So the bank had chosen to base the personal data processing on legitimate interest. However, the necessity and proportionality assessment had failed. And here the Hungarian DPA also mentions one excerpt from the joint opinion published by the EDPS and EDPB on the AI Act, according to which emotion recognition systems are highly undesirable and should be prohibited. Additionally, the Data Protection Authority found that also the employees' voices, the employees of the bank voices, were being recorded and analyzed. And there, because there is a power imbalance between the employer and the employee were qualified as vulnerable data subjects. So that would require even more safeguards taken by the bank, which was not the case. The DPIA had taken place, but it had failed to include substantial mitigation measures. All in all, the conclusion of this case was that the Hungarian DPA imposed an administrative fine for unlawfully processing personal data of its customers through the use of an AI system. This was the first case. The second case comes from the Italian DPA, and it has to do with the Replica app. So here we're talking about an AI-powered chatbot that generates a virtual friend for users to interact with. In other words, a conversational AI companion. This was also not targeted, but children could also have this companion. So there were definitely very high risk to minors and also other emotionally vulnerable individuals. The Garante, so the Italian DPA, found a lack of a proper legal basis to process children's data. There was no age verification mechanism, not even a gating mechanism for children, no blocking of the app if a user declared that they were actually underage. Additionally, there were several user reviews of the app that would report sexually inappropriate content being served. So the chatbot would reply, not many times not taking into account that it was also addressed to children. On the basis of that, the Italian DPA issued a temporary stop of processing of local users' data. So again, an action against this AI system. And third case, which I guess most of us are familiar with, is again coming from the Italian DPA on ChatGPT, where the Garante found that there was no transparency with regard to the information provided to users. There was a lack of a suitable legal basis for the processing of personal data in order to train the algorithms underlying the ChatGPT. Inaccuracy of personal data in terms of the system's output, and absence of an age verification system. And again, the measure that was taken by a data protection authority was the temporary suspension following a restrictive order against ChatGPT. Having in mind these three cases, I would like to make one first point. Am I good on time?
Yeah,
okay.
It's okay.
Perfect.
2 more minutes.
Yes. So all these cases are actually three enforcement actions against AI systems on the basis of data protection law. What does that mean is that data protection authorities used the GDPR to protect individuals against risks that have been raised from AI systems. This point is quite important to be made while we are going through a debate for a regulation of AI, because we need to be smart as to the way we want to regulate. We actually need to understand what the gap is of protection and address the specific gaps, and also be aware of the tools that we already have in place. And data protection law offers these tools. This is something, so data protection seems to be acknowledged by the co-legislators, and especially from the European Parliament. I could elaborate a bit more, maybe on a follow-up question. Having made this point, I want to clarify that that does not mean that a specific regulation on AI is not necessary. So, of course, I mean, this is something, again, that I could elaborate on, but I can bring some examples. Laura mentioned one obvious thing, which is that the AI systems do not only process personal data, so there can be impact on fundamental rights even when personal data are not being processed. So the GDPR does not apply. So we do need, there is a legal gap of protection, so we have the AI law to cover this. Also, another point in relation to the Hungarian Data Protection Authority case with regard to emotion recognition systems is the following. So we saw that there was a violation, multiple violations of the GDPR. However, looking into the AI Act, we see, especially in the version, the latest version that was adopted by the joint committees in the parliament, we see that there are specific there are specific emotion recognition systems that are being used in certain contexts that are prohibited. So they are in the prohibited list. Also, the rest of the emotion recognition systems are placed on the high risk list. So that means an extra layer of protection. Then I would also like to make a reference with regard to the AI Act, again, specifically mentioning the latest version from the Parliament, that there is a wide reference to the environment, so the right to the environment, which is something that we didn't have in the proposal from the Commission or the Council of the European Union. Also, I mean, I can elaborate more. I will just end with this one, saying that, again, in the latest version of the Parliament, we have the additional provision of having general principles for all AI systems, meaning high risk, but also low risk. And among these provisions, we also find principles such as human agency and human oversight, social and environmental well-being, technical robustness and safety, so having AI systems that are resilient. I will keep it to that, and then we can go more in detail.
Thank you. We will come back to several points, I think, because they connect nicely to things that Laura has already mentioned. And I'm going to go to Sarah because she's also working with the EU AI Act. And so, Sarah, I was reading that about like a year ago, maybe you wrote about the status of fundamental rights in the negotiations of the AI Act. And of course, these negotiations have since advanced and things have changed. Katerina has just mentioned that. So I was wondering if you could speak a little bit about the concern at the time that certain AI systems could in fact undermine data protection legislation. And also, what do you think about this interplay between existing data protection legislation, GDPR, and the AI Act? What are the gaps that Katerina was talking about?
Yeah, definitely. Thank you so much. Can you hear me okay? Yes. Great. Yeah, Katerina's intervention was perfect because I think I can jump nicely from there. So maybe I'll answer your question in 3 sections. The first about the gaps and the interplay between the AI Act and the GDPR. The second part is I'll go into a little bit about what is the state of the AI Act proposal when it comes to fundamental rights, human rights, and also some broader questions of social and economic justice. And then I think the last question is also like the link between sort of broad, let's situate these conversations of data protection, of harms, of fundamental rights into a broader question of like, why are we speaking about actually all of this for people's lives, but also the economy, and connected not just from Europe, but also to the global south, to the rest of the world. What does that mean specifically in terms of power? So I'll try to do that in how long? 5 minutes?
6.5.
6.5 minutes, great. Easy. The first question about the relationship between data protection and the AI Act, beautifully put by Katerina. So I think the first point that we took as the entry point for the work on the AI Act is that ideally this piece of legislation and what it could potentially achieve would be complementary with the GDPR, definitely not replacing it. Particularly, first of all, I don't necessarily believe that was the intention of the European Commission in proposing this regulation, though. So first and foremost, this is an internal market regulation, and we were told consistently from the get-go that this piece of legislation is really designed to regulate AI systems before they go onto the EU internal market. So primarily, the legislation itself, for those of you who aren't following it, was about defining and outlining the types of AI systems that are high risk, so that they undergo a series of technical checks as products before they are sold on the EU market. Now, that's a very different conversation, I think, from the many of the ones that we've been having here about what are the rights of individuals when AI systems are used, what are the harms, and also what are the broader concerns, even beyond data protection and individual rights, but also socially and economically. So that's how it started. But also for us, from our perspective, I think there are many types of things that the AI Act we saw as potential it could do. So as Katerina said, there are things that the AI Act could be much broader than data protection regulation, not just on the point of personal data, but I think that's also an important one to narrow in on. What type of AI systems that are used could harm people that weren't processing personal data? We increasingly, in areas of law enforcement and migration, saw the use of predictive systems that weren't necessarily centered on the individual. So, for example, a place-based predictive policing system or predictive analytics in migration control. These are types of systems that are used essentially to forecast patterns. Sounds innocuous, sounds not so scary, but actually what in practice the harm that can emanate from that is the redirection of policing activity, the redirection of migration control activity to certain areas, looking at their impact that are already over-policed, already potentially over-surveilled, and also in the migration context could lead to real harm and violations of international refugee law. So these are types of AI systems that are definitely impacting people by their use, but not necessarily the processing of personal data, which is why the AI Act helps there. Also around the question of individual information and remedy. So often a conversation also in data protection law is, okay, what access do I or you as a person affected by a particular system or data processing, what information do I get when I'm impacted by it? The data protection, GDPR says things about that. It says when there's solely automated personal data, you should have the right to be informed and have a right to an explanation about that type of processing. However, solely automated, as many of you know, presents a huge problem. Many AI systems are not used in a way where they are the only decision, the system is the only decision maker or generates the only outcome in that case. It is often used in a much more complex and rich way than that, often hand in hand with human decision making. That doesn't mean that no harms emanate from it, and that doesn't mean that an explanation still might be needed about how that AI system is used. Another reason why the AI Act is important to complement. The other one, and I think it relates a little bit more to what was already said about power. So we talked about emotion recognition systems just now. The EDPS said they're undesirable. We prefer unacceptable or extremely harmful. Not because they're just not cute, but actually because these systems prevent real harm to people in various different contexts. They operate in a system of broadly increasing surveillance and mass surveillance, and as such should be prevented. They shouldn't be allowed to be used, and then the burden put on individuals affected to go to court and litigate them. So that points to sort of another sort of reason why we wanted this piece of legislation to complement the GDPR is the preventative role. If we already see, as we saw in the AI Act, the idea that some types of AI systems should be prevented, then hopefully, ideally, then we have a system where we don't put the burden on affected people to have to prove in court time and time again that a prohibited system is used. That recognizes a certain power imbalance also. We talked about vulnerability. I prefer the term marginalization. There are some people that are just further away from the litigated system as others. Some people are much less able to go to court to challenge a certain data protection claim, much less able to challenge a certain AI system. How do we compensate for that? Preventative tool maybe is a blunt instrument, but actually addresses that differential of power relation. Also recognizing that when we talk about prohibitions of certain AI system, we might recognize that there are also certain contexts we might want to prohibit an AI system. So in the Parliament's version of the AI Act, you see that, for example, to continue the story about emotion recognition is proposed to be banned, but in certain areas, border control being one of them, the workplace being another, by police being another. That is interesting because it recognized that in certain topical contexts, in certain areas of life, there might be a higher harm than others. You can read between the lines to say it's also meaning that actually certain groups also are more likely to be affected in certain contexts than others. That's why to ban it in certain contexts might be useful. Migrants, for example, would be one reason. So therefore, we see in the AI Act much more, I think, of a recognition of the differentials of power, the power imbalance that comes about when AI systems is used, specifically against marginalized communities, racialized communities, the LGBT community, et cetera, et cetera. So, second part, the state of the proposal on so far. What we have basically seen is that we see the European Parliament, the European Council having completely different approaches to this piece of legislation. What much of civil society here in Europe want to see are four main things, and I want to share that with you because I think we're in a really interesting time for this piece of legislation, and it's a time to watch out actually how that goes if we're concerned about fundamental rights. So the first thing is prohibitions. We just talked about that. The European Parliament is proposing quite a list of prohibited practices. So in addition to emotion recognition, the Parliament is proposing a full ban of remote biometric identification in public spaces. So, for example, facial recognition to identify us in public spaces. They're proposing a ban in some sorts on predictive policing. They're proposing bans on biometric categorization and some others too, which I won't go into more detail of. Most of these, in some way, relate to police tech, police AI, the law enforcement and, in some way, migration use of AI systems to either identify us, categorize us, classify us, control us in some ways. So that's a really interesting development, a really powerful development that I think we need to watch out for. The second type of thing that we're seeing in the Parliament's proposal in the EU AI Act is increased transparency and accountability measures. So particularly when AI systems are deployed, not just when they're developed as products, we're seeing increasing measures by which the deployer of those systems, maybe it's a public authority, maybe it's a police force, maybe it's a company, should have to demonstrate how they are accountable for when deploying that system to fundamental rights. So, for example, one of the requirements that the Parliament is taking is that when a deployer of a high-risk AI system wants to put it into use in Europe, they should do a fundamental rights impact assessment, and they should outline some certain information that about the use of that system and how they're going to mitigate harms. And specifically, there is a line there specifically referencing how any disproportionate impact on marginalized communities might be felt. Super interesting for those interested in this question of data protection, fundamental rights, and vulnerability. The second set, the third set of things are the increasing adaptation of the EU AI Act to be a bit more holistic and cover things that are not just high risk or unacceptable risk, but also this category of general purpose AI systems, broader foundation models that sit underneath many types of AI systems, including the generative AI systems that we've seen in ChatGPT. The last set of things that we're really watching out for is how far this piece of legislation can further empower people beyond the GDPR. So this includes being notified when they are impacted by any high-risk AI system. For example, if you're applying for a job and an AI system is anyway used in the context of that in that place, then you should be informed about that, and you should also have a clear mechanism by which you can claim an explanation for that. Not just if that AI system is solely automated, but also in any way used in a high-risk area. Also, what we're seeing is that there are, in some ways, not perfect ways, mechanisms by which people affected can complain when an AI system that's regulated by the AI Act has violated their rights. And that's opening up this question of rights and remedies. How do people who are affected by AI systems challenge them? I realize I'm not the salesperson of the EU AI Act, so these are some things that we, as civil society, really fought for, and it's not a perfect piece of legislation. A lot of that stuff will be rolled back likely in the trilogues with the council. And so the battle now is how do we, especially as people interested in the fundamental rights perspective, how do we challenge that process? How do we make a clear and strong narrative for a fundamental rights-based approach to the EU AI Act? And that's really the moment we're in now. If I'm allowed, I have like one last point, which is about going a little bit beyond. So what is the relevance for all of this beyond the individual, beyond fundamental rights and data protection, and also beyond Europe? These are, I think, some of the questions that I think we need to be asked. And they're not legal questions, they're socio-political questions. So what the EU AI Act doesn't cover is when a harmful system, a surveillance technology is developed in Europe, but then deployed somewhere else. I was recently in a conversation about Palestine and the development by Dutch companies or other European companies of surveillance technology, but then deployed in Palestine. The EU AI Act doesn't yet say anything about that. So human rights in a more global sense are still not covered and at stake. But also fundamentally this question of, is data protection the right frame to address the harm that we're seeing in AI systems? Is fundamental rights even the right frame to address some of these harms? I think a really interesting thing for anyone that follows some Timnit Gebru and many of these scholars working on like broadly the socio-economic impact of AI systems is that we're not just talking about data protection and data harms. We're talking about labor exploitation. We're talking about environmental extraction. And we're talking about like how AI systems embed a global hegemonic order by which Western values, and particularly the values of people sitting in Silicon Valley, are centralized basically through these generative AI systems. In that sense, I would leave with a provocation: is data protection the right frame, or should we be talking about data production also? So understanding that these systems are not just they're not just naturalized, they're not just fact. Actually, so much goes into the development of these systems, so much goes into, in terms of energy and many other resources, goes up into the production of these systems. And challenging them is not just a rights-based issue, it's also an economic one too.
Thank you, Sarah. I'm being very relaxed with the time because I just want to hear you all speak. So, no, that was amazing. I think it's a nice segue also into RISPER, because my question was about I just need my phone just about your work and the Lawyers Hub work with AI in general, and also the Artificial Intelligence Practitioners Guidebook for Kenya. Because this is a document that is an example of looking at AI from several perspectives. So it's not just a discussion on the legal frameworks. There's also things about design. There's also the discussion about where those technologies come from, where they are deployed, and how those are not the same places. But there is, in fact, one section that is about the legal landscape for AI in Kenya. And it kind of acknowledges that there's a long path so far creating this regulation groundwork to eventually deal with AI-specific regulation. So my question would be basically for you to walk us through a little bit of this regulation groundwork and what has been discussed in Kenya so far regarding AI regulation.
Awesome.
Thank you.
Thank you, Mariana. Can you guys hear me? Good evening. I like the conversation that we've just had because you'll see it coming up again in my presentation. And the reason for this is you find that Africa as a continent, and Kenya particularly as a country, the conversation around, consumption, we are heavy consumers of technology, right? So we are importing and we are getting all this coming back home. And then in terms of the data, a lot of data is being generated from the continent, It's being used to analyze, it's being used to see how these technologies work. And so you find that many times we'll face the consequences of some of these technologies, but then you find that many times we are not really involved in the conversations, like you've just raised, even with the EU Act, the perspective where it doesn't look at the impact of the technologies outside of the EU. And so that takes us to the next conversation around how, even with that being the case, we are still very reliant on, for example, when it comes to policy making and regulation, we look to the EU a lot, and the GDPR is a good example. So you'll find, like, for instance, in Africa, many of the countries have mirrored the GDPR in their national data protection acts, and Kenya is a good example of that as well. And so based off of that premise, you will even see that with our constitutional provisions, the conversations that we are currently having, for instance, in Brazil, with the EU Act, AI Act, is actually going to be reflected within the Kenyan context, or even just generally within Africa. So when it comes to the Constitution of Kenya, which came in 2010, it has a very the conversation will center around the Bill of Rights, right? And so we have, for instance, Article 10, which focuses on national values. So conversations around, equality, dignity, non-discrimination. I think those are the same principles you find, for instance, in the OECD. And then a big conversation now, and I think this is something that has come up again and again in the previous presentations, that conversation about data protection. So we have the right to privacy under Article 31, and that is the premise through which we got our Data Protection Act in 2019. And you find that the principles therein, when you look at the rights of the data subjects, when you look at some of the obligations that the processors and the controllers are getting, they're very similar to the GDPR. They're very similar to, the different, the provisions that we have therein. And so that is what is supposed to dictate how we engage with technologies. But I like the question that we are posing, is data protection the only confines through which we are supposed to be addressing this question, especially because it's limited to just personal data. So what becomes of all data sets? And I think that's a conversation that's still lacking, even within the Kenyan context, the conversation around data governance holistically. So you find that we have the Data Protection Act. It's supposed to help us and guide us through, personal data and how to deal and interact with that, how to deal with DPIAs and have that as a requirement for controllers and the processors, have the requirement around registration just to see, who's playing within the ecosystem and so forth and so on. But then when we talk about issues as simple as just sharing of data, when we talk about, dealing in a commons, those are still not conversations that are heavily happening within our context. And so I like that the trajectory that has been taken is, how do we then address data governance holistically, other than just looking at personal data? Because as it stands within the Kenyan context, a lot of AI conversations are happening within the confines of personal data. And so you'll find that the right to privacy has highly been implemented, through the act, that is the Data Protection Act. But then when you look at, for instance, the consumer rights, and that's something that you've just brought up, how is this actually affecting the social being or the economic aspects of, our societies? We really don't have implementing power when it comes to that. And so we have it as a right within our constitution, but then how do we then, make sure that the consumers are actually protected? They can query different decisions, they can be able to participate actively within, whether it's the making, the deployment, or, how those particular technologies affect them. Then there isn't a very straight line to that just yet. And so I think that is the question that I'm getting from this. So just looking at the provisions that we have a very human rights-based approach, which I think is similar to what of the presenters have just mentioned. We have a very data protection oriented approach, which again is something we have said. But then when we look at one, just the general governance of data, and then when we look at two, issues around consumer rights, we still find that implementation hasn't per se picked up in that respect. And I think lastly, I think what we have seen a lot of activity on is just trying to have different institutions coming into the conversation. So you find the conversation is very segmented. So we have different aspects. So we have the Data Protection Authority in one space, we have the ICT Authority. We had a task force which was supposed to be working on distributed ledgers, blockchain, and AI. They were also coming up with, recommendations. And that is, the report that they put out is what would come close to being a national AI strategy, and that you find, across different countries. So South Africa, Egypt, we are having more and more countries moving in that direction. But then now with the conversation around, the EU AI Act, I'm very sure, again, we are going to begin having conversations in Kenya about an AI Act, you see. And so because we look heavily to the EU when it comes to policy making, when it comes to that sort of creation, it is very likely that whatever decision or whatever aspect is taken within, for instance, the EU as regards, policy making, or the US as regards the technologies, then that conversation you'll find most probably happening within the African continent. And so I think the query for me is how can we better plug in within the conversation? First, because you are very heavy consumers, and secondly, because of, the impact that you have said, when it comes to issues such as bias, something as simple as immigration controls, securing jobs, all these things automatically affect the continent. And so, one, how can we be, more engaged in the conversation? And then secondly, how can we make sure that whether it's in picking up the technologies as is, or even now beginning to build technologies that work for the continent or work for the Kenyan context, that we are actually doing it more actively as compared to just picking and pasting within our particular contexts. Yeah.
Thank you very much, Risper. Because of my flexibility with the time, I don't think we will have much time for audience questions, but I did want to do some quick follow-ups for each of you. And we now have to pay attention to the time. So maybe I was thinking, Laura, if you could briefly talk about, you were talking about the Brazilian context, and Sarah and Katerina mentioned the EU context, and we know there's a heavy discussion on the approach, the risk-based approach of the EU, and can you say a few words of the Brazilian approach to regulation, and if you think that it makes more sense to kind of tackle those gaps, that are still needed to protect individuals and groups.
Thank you so much for the question, Mariana. I think the Brazilian approach was from the beginning on. We tried to combine a risk-based approach, also with a high-risk list, but with rights and principles, because I don't know, we couldn't. We were aware that the European approach is very focused, or at least at the beginning of the process, very focused on the certification and product liability and so on. But we didn't focus so much on this side, but we really established a list of rights, such as the right of explanation, the right to contest decisions, and the right to know when you are dealing with an AI system. So the idea was to have also not only an administrative authority, but also the judiciary to implement the law. And I think that's maybe the major difference regarding the AI Act. I'm not going to talk a little more, but we can talk afterwards.
Yes, no, we were discussing that in the previous panel about vulnerabilities, and also how those different approaches can be either perhaps more useful in tackling certain vulnerabilities, either existing vulnerabilities or new vulnerabilities created by AI systems. So I think this has been like a common topic among panels. And Katerina, we were talking about the things that you wanted to comment a little bit more about. So Sarah also mentioned the newer version, the Parliament version of the EU AI Act. So if you could maybe elaborate a little bit on your perspective of the changes, especially regarding fundamental rights and what we are discussing here, the interplay between the frameworks.
Get it. Okay, thank you. So indeed, Sarah mentioned quite a few examples. I would like to say that looking at the history of the AI Act, that counts like 2 years, taking it from the beginning, I want to highlight, first of all, that one of the first opinions that were published with regard to the Act came from the EDPS and the EDPB. So one thing is that. Secondly, Sarah mentioned about the legal basis. I would say, as a general comment, if we compare the proposal of the Commission to the latest version coming from the Parliament, I would dare say that there is a big difference with regard to the references to data protection and fundamental rights. The Parliament's version being very way broader, so it has more extensive references. And I will bring some examples. First of all, Sarah mentioned the legal basis of the law on AI. It is true that the Commission proposal had the internal market legal basis as the primary and basic legal ground, and referred to Article 16, which is the legal basis for protection of personal data, let's say marginally. Only when personal data was at stake. Coming to the Parliament's version, there is a specific recital, and more specifically, it's recital 2A, so it's an additional one, talking about the legal basis of Article 16 on personal data protection, placing it, I wouldn't say equal, in an equal stand, but like giving it a broader scope as far as I read it. One second important difference, if I could say, is that privacy and data protection are among the general principles for AI systems that have been introduced in the Parliament's version. Another point is the fact that so in the joint opinion of EDPS and EDPB, one of the requests was to add as an additional criterion for the compliance, for the conformity assessment of high-risk AI systems, that deployers would, I made this too complicated. I will simplify by saying that in the versions, in the Parliament's version, it is required that high-risk AI systems are in compliance with the data protection legislation, and that was something that was asked by the EDPS EDPB opinion. I had one more thing in mind. Yes, with regard to the right to an explanation, again, Sarah mentioned it. So in the Parliament's version, we do have an individual right that is afforded to affected persons. This is a term that we see in the Parliament. That have a right to an explanation of decisions when they significantly affect individuals. So these are some of the examples of references to data protection in the AI Act. Yes.
Thank you, Katerina. That was a great wrap up of the previous your previous presentation. Yeah. Thank you very much. So Sarah, I was thinking you mentioned being a little bit pessimistic maybe about the next steps in terms of the advances that were reached, that some of them may be lost. So I was wondering if you could talk a little bit more about that, and also about how civil society may act, to kind of secure those provisions.
It's a very good question, because we're still thinking about what we can do. Yeah, I wouldn't say pessimistic, because I do believe that I think you have to ask. You have to ask for what people tell you is impossible. Also, a fun fact, we were told very early on in the AI Act, before even the Commission released the proposal, so I think we were told this in early 2020, that there would be no prohibitions and that would be impossible. And so here we are discussing like a long list of Parliament's proposed prohibitions. So I think always to be optimistic and see what we can push for, and also to be as critical as possible in those demands, I think is a really important thing. But yes, specifically going a little bit more, I think what we've been discussing is the main question as we move into the next stage of the EU AI Act is essentially how are the police's use specifically of AI systems regulated? Particularly because you have now what you see is the European Parliament announcing a long list of bans, but also looking for more transparency by which public actors use high-risk AI systems, so asking them to put information about those police systems on the public database, give more information about the impact, et cetera, et cetera. So we're talking about basically the question of how do we check the police, how do we oversight the police when they're using certain technologies. The problem is that in the next stage, what will be hugely sort of defining is the role of national governments, especially the home departments of these national governments will be now putting their foot down and saying, actually, we don't think we should have a full ban on remote biometric identification, actually, because we need it to find criminals or we need it to find missing children. So what we're encountering is kind of like two, maybe not to be too dramatic here, but like two warring kind of like narratives. One is the narrative that we do not want mass surveillance. We do not want more like oversight of us. We think that the use of certain technologies is explicitly discriminatory and changes the power imbalance in our society. That's one narrative. But also the narrative coming from the governments, which is saying, we need these surveillance technologies to police the Olympics. We need these surveillance technologies to keep us safe. We need them to stop terrorism. We need them to find missing children. So to the last bit of your question, what will we do? What we're trying to do is think about what is our broader narrative on why we need accountability for the use of police technology. Why does it produce harm? And actually, what is our alternative narrative for this? Here, I would now like sort of revealing like my background in racial justice in essentially that I would propose we essentially using an abolitionist framework to look at that, which is essentially that we would take all of the we take a look at all of the resources that are going into border walls, drones, technology, facial recognition, et cetera, as carceral technologies, as technologies of discrimination, of punishment and control, and saying, what would we want instead to do with that money, that resources? We want actually policies that keep us safe. They might not be tech-based policies, but actually we need more oversight. We need to dismantle the systems that produce the increased resort to surveillance technology and harmful systems, harmful AI systems. And we need to think about other ways that we can think about safety and security in our communities. So that's what we'll be doing.
That's great, and we should talk more about that, because in Brazil there are several campaigns to ban facial recognition, and this is one of the narratives that some of them are discussing and have been kind of gaining, traction. So that would be a very interesting discussion. So to finalize, Risper, you were talking about kind of being able to foresee that the impact and the effects of these discussions taking place in the EU, and how it will probably also happen in Kenya with an AI Act discussion. So my question to you would be, it's a hard question to finalize the panel, but how do you think would be a good approach, at least to start from a perspective of Kenya and not a perspective of the EU?
I think something that would help, and I think is already picking up, is, the issue of skill, and digital talent. So equipping the community, the practitioners, to actually understand the conversation happening, and especially even not just the practitioners, because I think we have some traction there, but the policymakers, do they understand data protection? Do they understand AI? Do they understand even regulating within that particular space? And so, for instance, you find like at the Lawyers Hub, we're trying to push for digital policy making and understanding with the parliamentarians, for instance, in Kenya, and see how that can now nurture that community to actually be able to go ahead and make better laws. And I think secondly would be, pushing for localization, whereby we are getting local contexts as opposed to just copy pasting onto the platform, because then it won't make sense. And I think even with the GDPR, you find that one of the arguments that has been made is we are very communist in our nature, right? Ubuntu. So you find in SA, South Africa, they move together, we move as communities. And so the GDPR is a very individualistic approach, it focuses on the person. So is it actually applicable within our context, or how will we then make it applicable within our context? And so moving from, just copy pasting and actually contextualizing the communities that we live in, and then actually now having things that serve us and are actually helpful would be the second thing I'd propose.
Thank you so much. I think that was perfect to just end the panel. Actually, we have 3 minutes and we started a little bit late. So, we have few of you here, but I was wondering if there is maybe one question, and otherwise we can just go to the cocktail. Everyone's tired. No questions?
The question is, do you want a cocktail?
Yeah, so I think, so that's it, guys. Thank you for staying. Thank you.